Guide for Immigration Health Surcharge for Sponsored Workers. Today's video update talks about Sponsored Workers Immigration Health Surcharge Process. Underlying secondary legislation needs the Immigration Health Surcharge to be charged as per the length of immigration authorization given to an individual. However, up until the 1st of February 2022, the Home Office portal used the length of a primary candidate's certificate of sponsorship to figure out the amount payable for the IHS. The Home Office has corrected the IHS process to address the last undercharging for sponsored employees. Stakeholders were informed of the change on the 4th of February 2022 through email.
Brightest and the best.
Changing the UK
Single global
immigration system.
Following are the changes that have been made. No IHS is payable where UK immigration authorization is granted up to a total of 6 months. After that, the IHS is payable at a rate of £624 per year, individually. If an individual has half-year immigration permission, they will spend £312 for that duration. If the half-year is over 6 months, the total annual amount of £624 is payable. The immigration rules allow sponsored employees to be granted immigration authorization for a short time before and after the dates listed on their costs. In many cases, the portal has been undercharging primary candidates by £312. This system error did not affect the calculation of IHS payments for dependents. For example, the immigration rules say that a skilled worker course can be issued 5 years. An application might be submitted up to 3 months before the start date mentioned on the course, and immigration authorization might be granted for 14 days after the end date of the course. Therefore, an individual with a course granted for 5 years may be given immigration permission from 5 years and 2 weeks to roughly 5 years and 14 weeks. Let's discuss a sponsor who avoids this additional cost. A sponsor might avoid this additional cost by decreasing the length of the course. The scale of such decline in specific cases will depend on the sponsored work class and how far before the course start date the immigration permission can be valid. A sponsor would also be required to consider whether decreasing the length of a course might lead to a shortfall in the overall immigration permission needed for a sponsored worker to qualify for settlement. If the decline is too significant, this could lead to further extension applications that need to be made, which would entail the necessary attendance cost and administration. We have reached the end of today's video. If this video was helpful for you, subscribe to our channel for more updates.